Okay, guys, got another video for you today. Today, I'm going to show you the difference between payoff or, payment, pay, set off, all that stuff. All right, we're going to go over that, the differences and similarities between these. All right, so first off, let's go to here. I'm going to go Black Laws Dictionary, and we're going to go to set off. Okay, so set off, a counter demand which defendant holds against plaintiff arising from uh, uh, out of a transaction extremes of a claimant's cause of action. Okay, right? A money demand, right? Or here, sorry, counter demand must be liquidated or capable of liquidation, grow out of a contract or judgment. A money demand independent of and unconnected with a plaintiff's cause of action, right? And then it says a set off, only a counter demand upon which a defendant at commencement of action may have maintained independent suit. Set off, both at law and in equity, is that right which exists between two parties, each of whom, under an independent contract, owes an ascertained amount to the other, and to set off his respective debt by way of mutual deduction, so that in any action brought for the larger debt, the residual only after such a deduction shall be recovered. Now look what it says here. This is interesting. It's a right between these two parties. They owe an amount to the other. Okay, so it's not like a one-sided thing. Both people have an obligation to each other. Okay, kind of interesting, isn't it? A set-off was unknown to the common law, according to which mutual debts were distinct and indistinguishable except by actual payment, release, or agreement. Oh, so there's three ways. There's an agreement, a release, or payment. Okay, for debts. A defendant who has brought a demand against the plaintiff was compelled to bring a suit or resort to uh, an equity court to have his claim set off. Okay, the English statute, which has been generally adopted in the United States with some modifications in case of mutual debts, however, allowed the defendant to set his debt against the other either by pleading in bar or giving it in evidence where proper notice has been given to such intention under the general issue. The statute being made for the benefit of the defendant is not compulsory. The defendant may waive his right and bring a cross action against plaintiff. Look at that. So you have the right to sue the person back. Okay. Pretty interesting. Now there's a bit more in here, but they talk about counterclaim. Independent of statute is the right of set off of equitable origin, right? So you see, it may be a payment, but it may not necessarily be a payment. It could be a counterclaim. It differs from a counterclaim in that a counterclaim arises out of the same transaction described in the complaint, while a set off is independent thereof. Okay, and it says see recoupment. Set off differs from a lien in as much as the former belongs exclusively to the remedy and is merely a right to insist. Now we're going to look at payment here, okay? If we look at payment, we get something interesting. So first, pay is compensation. A fixed or definite amount given by law to persons in military service in consideration of and as compensation for the personal services. Okay. Now to pay is to discharge a debt. To deliver to a creditor the value of a debt, either in money or goods for his acceptance. The term, however, is sometimes limited to discharging an indebtedness by the use of money. Okay, so that's pay. So it's discharging a debt. Well, what is payment? The fulfillment of a promise or the performance of an agreement. Now, if you pay a company, let's say you pay a mechanic to fix your car, you pay him $500, and then he doesn't do it. Well, did he pay you? He's supposed to. That's his payment to you. You gave him Federal Reserve notes, and he's supposed to perform his end of the agreement. It's technically a payment. Isn't that interesting? It's the fulfillment of a promise. I promise to fix your car if you give me $500. A discharge of an obligation or debt and part payment, if accepted, is a discharge pro tanto. Okay, so here, let's see, we'll look up pro tanto. You're going to pull it up here. To such an extent, to that extent, okay? So to that is pro tanto means up to that amount or to that extent, right? So if accepted is a discharge pro tanto. So up to that amount that was accepted. In a more restricted legal sense, payment is the performance of a duty, promise, or obligation, or discharge of a debt or liability by the delivery of money or other value by a debtor to a creditor, where the money or other valuable thing is tendered and accepted as extinguishing debt or obligation in whole or in part. Also, the money or other thing so delivered is considered payment. Here's your payment. Okay, so it's a verb and a noun, essentially. That's what it's saying there. Okay, so we can still say payment when we're using instruments because that instrument should have value. Okay, now notice it says in a more restricted legal sense, payment is the performance of a duty, promise, or obligation, or the discharge of a debt or liability by the delivery or other value by a debtor to a creditor, where the money or other valuable thing is tendered and accepted as the extinguishing debt or obligation, whole in part. Satisfaction of a debt in coin of the realm. So there, that's more about using gold and silver. Now it says here, payment implies discharge of an obligation according to its terms or by something given or received of agreed value equal to the debt or liability. So let's say you go pay a guy to fix your car, you give him $500, tells you, sorry man, I can't fix your car. Dude, what the heck? It's like, yeah, it turns out it's a lot worse than it was, and you want your money back. Well, give me my $500 back. He goes, I'm sorry, man. At the time, I just don't have it. Okay, I used it. I shouldn't have. You're right. But I tell you what, I got a car that can replace that one for you. It's only $2,000, but I tell you what, I'll $1,500 and it's yours because I already owe you the 500. So I'll take $500 off of that. All right, I'll take a look at the car. You see, so now we're agreeing on the value is equal. Hey, I'll give you $1,500 for this $2,000 car because I already owe you $500. Or you could say, tell you what, I'll let you borrow a car of mine in the meantime at no extra charge until you get another car. Okay, because I took your $500. Then they got then maybe the mechanic has a car that he can lend them, like one of those loaner cars or something. So he just at least gets around in the meantime, right? That would be agreed value equal to the debt or liability. That's if he agrees. He goes, no, I want my car back, or no, give me the money back, whatever. He might go, all right, you know what? That's fair. At least I got a car to drive around in the meantime. Payment of a debt involves both tender by debtor with the intention to pay debt and acceptance by creditor. Tender by creditor with intention to pay debt and acceptance by creditor. So they have to accept it. Now remember, we have UCC 3-603 tender payments. As if they refuse your payment, it's still discharged to the amount tendered. Okay, so it would be, it's still a payment, although here it says payment, intention to pay debt and acceptance by creditor. So if you're sending them an instrument, you do have the intention of paying, but you can't really pay, right? It's supposed to be something. Well, technically here it doesn't say you need gold or silver coin to do it, except up in this spot right here. Okay. Anything delivered and accepted in discharge of obligation is payment of debt. So anything delivered and accepted in discharge of obligation is payment of debt. Anything delivered. You send the guy 1,000 bananas. If he takes it, well, there you go. Okay. That's your payment. Though payment in a broad sense includes money or anything else of value which the creditor accepts in satisfaction of his debt, it means in its restricted sense full satisfaction paid by money and not by exchange or compromise or by an accord in satisfaction. Okay. Now, accord and satisfaction is a different thing. I'm not going to get into that right now, but I will make a video just about accord and satisfaction. It's in the UCCs, so it's in there. All right. So now payment is generally understood to mean a discharge by compliance with the terms of the obligation or its equivalent, while in an accord and satisfaction, the discharge is affected by the performance of terms other than those originally agreed on. Okay, so just to give you a little more insight in there, accord and satisfaction. The execution delivery of negotiable papers is not payment unless it is accepted by the parties in that sense. See, now that's kind of a key thing here. See, people don't realize, that they have to accept it. And you can say, well, they're not accepting me. What do I do? Well, did they send it back? No. Then they accepted it. They never send it back. On rare occasions do they send any of these things back. When they do, they didn't accept it. But then you have to find out if they made copies, because sometimes they'll make the copies and try to redeem the copies. They're smart, but technically the copy's not going to fly. Okay, but it says right there. Remember, postal rule. It's been accepted once you mail it out. It's accepted. Okay, if they don't send it back, it is accepted. Obviously, they didn't send it back to you, so they didn't reject it, did they? They just told you they rejected it. So, and people freak out about this, and I understand. They're like, oh no, but they're saying, it's on my credit report still, or it's still on it's still on my bill. And they go, yeah, well, they're just not being very ethical, are they? They're not being honest or ethical. And that's why you gotta hammer this down on them. Pleading. When the defendant alleges that he has paid a debt or claim laid in declaration, this is called a plea of payment. Okay, partial payments. I think people know what that is. Payment into court. The act of a defendant in depositing the amount which he admits to be due with the proper officer of the court for the benefit of the plaintiff and an answer to his claim. Okay. All right, so that's that. Now we're going to look at discharge. Let's go look at discharge. I got some banging out there. Discharge. Nope. Discharge. To release. Liberate. Unburden, disencumber, dismiss. Extinguish an obligation. I think about when you discharge a debt, you are liberated from it. You are released from it, right? In the law of contracts, to cancel or unloose the obligation of a contract, to make an agreement or contract null and inoperative. Now, this is kind of interesting. If you go read your contract with somebody, you can find things as a way to null or make the contract inoperative. You can do that. But you have to read it. Go read the contract, look up the big words in there, go find out what they mean, go look at the legal terms in the Black Laws Dictionary, and read your contract. Okay, piece by piece, little by little, and see what in that contract is that you or they made null or inoperative. And then you can discharge the contract that way. Okay, there are ways to do that. But you've got to read the contract. As a noun, the word means the act or instrument by which the binding force of a contract is terminated, irrespective of whether the contract is carried out to the full extent contemplated, in which case the discharge is the result of performance or is broken off before complete execution. Okay, so an instrument, which is the binding force of the contract, is terminated, right? So you have this agreement, something in the agreement gets ripped out, right? Let's say let's say you go work for a hot dog vendor, and in the contract you have with the hot dog vendor, it says that you won't eat any cheeseburgers. And one day you're at a party and you eat a cheeseburger. Well, guess what? That contract you have with the hot dog vendor is now terminated. Okay? You may have signed on to work for the guy for 2 years. It's been a year and a half. And you just bit into a cheeseburger because you weren't thinking about it at the moment. But technically that's void, right? You've now ended the contract. Okay? Discharge is a generic term. Its principal species are rescission, release, accord and satisfaction, performance, judgment, composition, bankruptcy. As applied to demands, claims, right of action, encumbrances, to discharge the debt or claim is to extinguish it, to annul its obligatory force, to satisfy it. And here also the term is generic. Thus, a debt, a mortgage, a legacy may be discharged by payment or performance, or by any act short of that lawful in itself which the creditor accepts as sufficient. Now, remember, the creditor doesn't really have a choice. Doesn't have a choice in what he can take as payment as long as it is a form of payment. Okay? To discharge a person is to liberate him from the binding force of an obligation, debt, or claim. There is a distinction between a debt discharged and a debt paid. When discharged, the debt still exists, though divested of its character as a legal obligation during the operation of the discharge. So what they're saying there is that the debt still exists, okay? It's still there. It's just been set aside, right? That's why we looked at set off before. But its legal obligation is kind of pushed aside somewhere else. Something of the original vitality of the debt continues to exist, which may be transferred, even though the transferee takes it subject to its disability incident to the discharge. Okay, that's a weird sentence there, but basically it's saying, hey, look, if you send, let's say you send your utility company a coupon and they discharge that debt for the month with the coupon, right? That debt still technically exists, but its legal operation or obligation, the legal obligation is kind of being pushed off to the side. It's set off from being put onto you, okay? The fact that it carries something which may be a consideration for a new promise to pay. So you hand them the coupon, they go, okay, all right, we'll take it. Fine. But they still have this thing that says that there's an order or promise to pay them. Now they have it. Who owes them? Well, since 1933, it's been the United States government, right? That's the ones who have to pay. That's why it's an obligation of the United States, the coupons, or anything else that you use that's in that list. Anything that you use that's in that list is an obligation of them. So they're the ones that have to pay. You're just promising that they're going to pay. So as to make an otherwise worthless promise a legal obligation makes it the subject of transfer by assignment. See, look at that. See what it says there? Watch this. The fact that I carry something which may be a consideration for a new promise to pay, so as to make an otherwise worthless promise a legal obligation makes it the subject of transfer by assignment. See, so that thing would be worthless, but they're going, you know what? We're going to take it. Right? You write on a piece of paper, paid in full, and send it to somebody. You might consider it worthless, but it carries that consideration, right? And now someone else is going to have to pay it. Discharge by operation of law, where the discharge takes place, whether it was intended by the parties or not. Thus, if a creditor appoints his debtor, his executor, the debt is discharged by operational law because the executor cannot have an action against himself. What in the world does that say? Read that again. Discharged by operation of law, where the discharge takes place, whether it was intended by parties or not. Thus, if a creditor appoints his debtor his executor, the debt is discharged by operation of law because the executor cannot have an action against himself. Take that one in. That's a nice, interesting one, isn't it? You go, how can I use that? Use your imagination, but also read this. Okay, go read that case law. Or, I don't even look like case law. I'm not sure what that is. B note 1. Okay, whatever. Anyway, check that out. But that is pretty interesting, right? And then we go into other things. We go into criminal practice, stuff like that, equity, maritime law, the unburdening or delivery of cargo. Okay. Military law. Okay. Anyway, just wanted to show you guys this thing about discharge, payment, set-offs, and what this stuff really is. And use your imagination now that you're looking at this thing. See, how could you use that concept or those concepts in there to handle some of these debts of your own? All right, that's it. I'll see you guys in the next video. Peace.